The following program is suitable for general audience of any age.
Tonight, we discuss the fundamentals of the laws of evidence. How well developed is this legal area, and is there room for improvement considering the current context? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty here on other Derana News channel. Today as well we have very key legal concepts that we want to break down to the layman. And today's topic is a very fundamental one that we haven't been able to appropriately address in any of our previous episodes, and that's on evidence and the laws surrounding the fundamentals of evidence law. Specifically, we have an individual that's not a new face on this program, and it's very well suited specifically in the criminal aspects to talk about evidence and its nuances. I'm very warmly inviting onto our program here today President's Counsel U.R. De Silva. Thank you very much, sir, for coming back to the program once again.
Thank you so much for inviting me again, and it's a very wonderful and popular program, so it's proud to be here with you.
Thank you so much once again, sir. A little bit of an introduction into how we are going to be addressing this topic. First, we'll be getting into the fundamentals and the basic concepts. Next, we'll be getting into the current context and what we can see as practical difficulties as well, especially considering the recent developments that we have seen in the legal sphere. And finally, we'll be talking about what we can expect to see moving forward with future reforms.
Hello, my name is Anjana and I'm a data science enthusiast. My question is on fundamentals. What laws govern evidence in Sri Lankan court proceedings?
All right, without any further ado, let's get right into this discussion. We have a lot to cover and I think we should start with the basics first and foremost. Thank you once again, sir. We have a lot to get down to, but how about we start with the basics? Can you please explain to us in some sort of understandable capacity, because it is a vast area of law as well.
You correctly pointed out the way that we should put it to the people, because it's a vast area, and we must not educate them by giving this evidence ordinance. So there are a number of sections. This is a very old enactment, 1895. It was enacted by British people, and up to now there are few amendments, but we see it's a very important area to prove a case beyond reasonable doubt. In our criminal law, it is stated that if you want to prove a case, you have to use evidence in a proper way, and then thereafter it should be proved beyond reasonable doubt. So when we consider the criminal aspects, now we can come and say that penal code is the area enactment where it defines a lot of criminal acts in Sri Lanka. Apart from penal code, there are other acts as well to define the various criminal activities. So then there is Criminal Procedure Act, where it gives the way that the criminal code should adhere to and what are the procedures adapted to from the beginning. Now, when a criminal act is being done, evidence should be collected by the police. So that is how it says that the police should go and collect all these evidence in a proper way and then arrest the person who is concerned or is responsible for the criminal. It is alleged to have committed the offense, but finally it will be decided by the court, and till such time the police gather evidence and then arrest a person where they think that he is responsible. That is not a finality. So then thereafter, they will bring to court and produce before the magistrate and ask the magistrate to remand or grant bail, and thereafter it will be proceeded in that way. And then they collected all the evidence and send it across to the Attorney General's Department, or else if it is a criminal act where they can file a case, where police will file a charge sheet in magistrate court. Then only the criminal case will be starting to proceed. to proceed with the criminal case, we use evidence. That's how evidence come into play. So evidence is very essential for the prosecution, and then defense will show to court that this evidence is not properly brought to court, and then the court should not adapt, or the court should not listen to their version because it has not been produced before court in a proper way. That is how the evidence should be used for the criminal act. And evidence can be divided into various areas. Now, as far as the evidence is concerned, the most important thing is eyewitness comes and give evidence, verbal evidence. So that evidence will be there for the judge to consider whether it can be used or not. And then there are documentary evidence also, electronic evidence, and circumstantial evidence. So those are the various areas where a prosecutor, a person who is prosecuting case, should come before court and produce those evidence according to law.
So I think that is a very apt and very foundational introduction into this discussion, specifically because now in recent developments as well, we have seen that this concept and of the fundamental concepts of evidence has been coming into question as well in recent times. I want to ask you, sir, related to the act that we have, the legislation that we have, the evidence ordinance that's already in place. As you mentioned, it's very old, 1895, I believe. Do you believe, as a counsel that's practicing, that this ordinance is adequately updated to current times, or is it a little bit archaic?
No, it is a very useful and properly constituted area, act, where we have to develop in such a way that it will not affect the main body. So the electronic evidence came into operation later, and because of that there is a separate act as well as amendment for the purpose of producing that document or the electronic evidence. So apart from that, other areas are very, very properly constituted, and then we are using it in proper way. But the fact remains that some officers or the police investigations are being done not according to the evidence ordinance. That is the way, that is the reason, as you mentioned, we see whether a lot of confessions are being produced before the social media. It is prohibited. Now, in we must inform the people that the confessions which are given to the police officers while they are in custody, it is not being properly admissible. So it shows that evidence ordinance clearly stated that evidence ordinance is there to safeguard that evidence confessions, because once a person gives a confession to police officer, they are trying to bring that to court, but it is not admissible. There may be relevancy for their investigation, but it cannot be used as evidence in court. So that is why we say you can get a confession from a person while investigating being done, but don't produce before social media or any other media, print media. So then it will be effective to the investigation and then finally the outcome of the case. So that you have to be very careful when we are giving the confession to the media.
That is a very curious question as well. I want to harp on that fact a little bit relating to admissibility of evidence. Sir, can you please help us to understand the distinction between the admissibility of evidence and also the relevance of evidence?
A very important area, because there are a lot of things that are relevant, but you can't go to court and ask the court to admit those. That is called the admissibility. Admissibility. Now, for the example, you come and say somebody has informed me about something that had been done. So that is called hearsay. So hearsay evidence cannot be accepted. That is there is a relevancy for that, but cannot admit in court according to evidence ordinance. Hearsay evidence is totally we are saying that the Evidence Act clearly states that hearsay evidence cannot be adopted as evidence to prove a case in court. So that is why we are asking them to adhere to the concept of criminal law or the evidence ordinance and go before court and produce the relevant evidence which can be admit to court while the court case is proceeding.
Yes, that's a very key point as well. As you mentioned, there is a sort of etiquette that is required, and the guideline has already been given as well.
It is clearly stated in the evidence ordinance. And as I mentioned earlier, the confessions also same. They are clearly stated that you can't get the confession into evidence. The relevancy is there, but admissibility part, it should be adhered to according to the evidence ordinance in our law.
It greatly diminishes the value of the confession, whatever evidence that has been, the potential to be produced as well. I want to ask you, sir, relating to the now, during the court proceeding, the action of burden of proof. How does the admission of evidence and also maybe the balance of evidence reflect upon burden of proof, specifically when it comes to criminal proceedings? Because I think that's an area that requires a little bit of clarity for the general public.
Now, according to our law, once a person is being taken into custody, that does not mean that he has done the criminal act. So we see till the conclusion of the case, after the appeal is over, only we can point out and say that he has done this criminal act, and now he is committed to that, and then the case is proved beyond reasonable doubt. Now, our criminal law, it is clearly stated that prosecution should prove the case beyond reasonable doubt. Apart from civil law, it's different. Civil law, balance of probability. But in criminal cases, you have to prove the case beyond reasonable doubt. Now, till such time, that person is being considered as an innocent person. And he has all the rights to be there and listen to the evidence. And finally, if the prosecution fails to prove the case beyond reasonable doubt, he will be acquitted. So that is why we say the police should collect the relevant admissibility evidence and produce before court. Otherwise, merely because they collect some evidence and bring to court, that does not mean the court can convict the accused at the end of the case.
That's, I want to get specifically with your experience as well, sir. Now, as you mentioned, now there is a lot of nuances when it comes to understanding, of course, the relevance and admissibility of evidence as well as burden of proof. But when it comes to your practical experience, what are the challenges that lawyers have faced or maybe legal representatives have faced when it comes to the presenting of evidence in court? Not just what you mentioned relating to, proliferation in social media, but there might be other aspects, areas where evidence has become inadmissible. Can you tell us about that, sir?
Yeah. Now, we say when the criminal act is there, the witnesses are important. Our law says important area would be as soon as you see the crime, you must go to courts, you must go to a police station and then give the necessary details to the police. So that is the fundamental thing, where if you are delaying it, that is the court will think that you have heard something or you have asked somebody to give that particular area, and then you have gone to police and stated like that. So belatedness is a crucial thing where most of the criminal cases the court will not consider because of the delay. If you are in a position to explain the delay, of course, in a proper way, acceptable way, then of course court will consider. Sometimes witnesses will be threatened, and then they will come out with that story as soon as possible, and it can be considered as a relevant fact. But if purposely, if they are not in a position to explain the delay, then the court will think that that evidence cannot be accepted in final decision. And the other one is once you say, if I see the person, I can identify. If the police are going to show to the media and then go, send him to the identification parade, totally failure. Total failure is there, because the final part would be that he had been shown to the whole world. And then what is the purpose of having an identification parade? That is the reason we say that if you arrest a person, if the witnesses say that I can identify if seen, then immediately you cover him and produce before the magistrate and ask for an identification parade. That is the correct way of producing. Those relevant factors are admissible in court if he is being properly identified in a court identification parade. That aspect should be informed to the world, to the society, and then thereafter they know that you must not, even if you see something, you must not put it to the social media and then try to get some something which you like to have. When you show something, you think that you have done your part. That is not correct. You have ruined the matter. Now, in recent times, we have seen a lot of people have been arrested and show to the world that this is the person we have arrested and this is how he gives the story. That factor itself will ruin the whole case, and because of that, you have to be prosecutors or the investigation officers should be very careful when they are doing a proper job. They go and immediately they try to arrest a person. That's a good move. But thereafter, what they do will affect the case later.
We have to get to the specifics of the rest of the procedural challenges as well. I think there's a lot of, the roles that are played by forensic teams as well. And as you mentioned, there are multiple different means of evidence that can be submitted as well. I want to get to those specifics, but we do have to take a short commercial break. We're going in for a short commercial break now. This is Law, Land and Liberty on Other Derana News channel. Stay tuned. We'll be right back.
Hello, my name is Shinoli and I'm a legal professional. My question is, on the current context, how do modern developments contribute to better evidence procedures?
Welcome back to Law, Land and Liberty. We're in conversation with President's Counsel U.R. De Silva. We were just discussing the fundamentals of evidence law in the criminal context, and we just got done with an introductory segment with understanding the fundamentals. Thank you very much for the previous segment, sir. I believe we covered as much ground as we could with the basics. There's this question that I wanted to ask you previously as well, when we're still along the same lines as when we left off before the break, specifically relating to the process of admitting evidence. When it comes to the documentation or the proper procedure that has to be taken forward when it comes to different types of admitting evidence as well. You mentioned on the police reports, but there are, as you also previously stated, electronic evidence, documentation. Can you please tell us about issues that could come about, for example, tampering with evidence, and also maybe improper documentation processes when it comes to admitting the evidence? How does that reflect upon an ongoing case?
Now, in a case of criminal nature, as I mentioned, the verbal evidence, a person can see and then give the statement to police. It's very important. And thereafter, if there are no evidence, or if you want to improve the case or to corroborate more things, then there may be documentary evidence. So those documents should be very, if you are going to produce those documents, firstly we see that the original should be there. Original document is the key factor when you are proving a case before court. But that does not mean that if you have another photocopy or any other duplicate, so that evidence is also admissible, but you have to show how the people should inform court about the way that they took the photocopy or the copy of that particular document. If the document is not available, but the copy is available, that copy was safeguarded, then it can be produced by showing to court that how the original document destroyed or what happened to the original document. Sometimes the original document cannot bring to court. They are not in a position to bring to court. Then they can give evidence with regard to that and get a copy and state that we have taken the copy of from the original. If that person who took the copy of the from the original, then he will come and give evidence. That evidence can be accepted in court. Apart from that, the other documents are the medical reports. JMO's report, then the doctor will come and give evidence. In that report, there is a special area where it says history. So once the person is being produced before the JMO, the JMO will ask what actually happened. So then he put down the history of that. That is very important in a criminal matter, where in most of the cases we see that they go and say, I can't identify the person who did. But when they come to give evidence, they come and say, I saw this particular accused doing this. So that is how the inconsistency comes in. That is why we say that most of the people should know, the lawyers especially, when they are appearing for defense, they must go through the medical report very carefully and see the history and the injuries as well. So sometimes injuries will contradict with the version given by the person who is giving evidence. That will affect the case. And apart from that, the other evidence, of course, once the person is dead, JMO report. Apart from the JMO report, we say the person is being injured, JMO report comes, and then the doctor will come and have the post-mortem. Post-mortem report shows the injuries. So that is also important to prove a case, what are the injuries and how it had happened. In that way, the doctor can explain. That is also evidence in courthouse. And then comes the government analyst. Especially with regard to the drug matters, we always say when chain of production is very important as far as the drug cases are being conducted. Because once the person, the police officer took the quantity or the drugs into his custody, he should give evidence with regard to the same production going to the government analyst. If there is a break with regard to a chain, then the court will not going to take into consideration, and the court will say chain of production is very important. You all have not proved the case beyond reasonable doubt because the chain has dropped in some area. The government analyst should come and say what he observed and what he did with regard to heroin, and the quantity is very important, and then he analyze it and come and say this is the actual amount. Those evidence are very important as far as the prosecution case is concerned. And then the EQD reports, that is also in another area where the case can be proved because of the handwriting and other things that are important for the prosecution case to be proved. In a way that the court will see all the documents, and if the court is of the view, the court can get an opinion only. The court is not bound to accept those evidence, but court can get an opinion, and finally court will go through all the evidence and finally come to conclusion whether that evidence can be accepted and then convict the accused. That is why we say documentary evidence are very important. And the electronic evidence is also another aspect where the prosecution can prove the case. We are using a lot of mobile phones, and then CCTV cameras and other electronic equipments are essential for a case to be proved. So when we see something and then if we are in a position to record those crime, you must not put to the social media, you have to go and immediately give it to the police for them to conduct the evidence properly. It will be very useful. If a person is going to get that evidence into his mobile phone, they are doing a good job if they go and produce before the police for them to conduct. And then the other important thing is CCTV camera. CCTV camera footages are very essential, but the fact remains whether we know immediately if you get it only, you can produce before court, otherwise it will be automatically deleted. So then there is no purpose of going ahead after some time. Immediately you have to get the footages out and produce before the police. Police also, now in recent time we saw police have gone through all the CCTV footages and clearly they have come to a conclusion how it had happened and then what follows. So that is how a criminal case can be proved by collecting proper evidence. And if you are in a position to prove that in a proper way according to Electronic Evidence Act, then it is very easy after giving notices to the opposing party. It is the duty of the prosecution to give prior notices to the defense, and then thereafter they can produce those documents, those electronic evidence. And especially with regard to the conversation recorded by somebody, that is also very important when we are using it in a way. And then voice recording, of course, then if they produce before court, then the court will give necessary instruction or the orders for the police to take over those recordings and then send it across to the Government Health Department. Government Health Department will clarify the voice and say this voice can be identified clearly and this is the voice of the accused person. So that is also very important and very essential evidence if we are in a position to do so. And other important thing is when we are saying that we are in a particular area, if the mobile phones we can get the detailed report from the various people and Mobitel or Dialogue or any other areas, when they come and give evidence like that, it is very important to have that this detail of the telephone conversation, and then what we say in a statement can be proved by showing the things that are getting from the various people according to the evidence available with regard to this electronic evidence. So that is how a criminal act can be come to conclusion with evidence. So that is why we say the evidence is very essential. They are playing a very important role as far as the criminal cases are concerned.
The essential nature of evidence can be seen across the board as well when it comes to different types of evidence, as you just listed out very rightly as well, sir. I want to ask you about what we can expect to see moving forward as well when it comes to the future of the legal landscape surrounding evidence, especially in a criminal law setting and a criminal procedure setting as well. Before we get into any of those specifics, we have come to time on this segment. So let's take a very short commercial break. You're watching Law, Land and Liberty on Other Derana News channel. We'll be right back with the final segment. Stay tuned.
cybersecurity analyst. And my question, in the future, can we expect reform and amendments to the existing evidence legislation in Sri Lanka?
Welcome back to Law, Land and Liberty. We're in our final segment in conversation with President's Counsel UR De Silva on evidence law in the criminal law context. Specifically, we were just getting done speaking about the very basics, the very essential areas for a common person to understand exactly the importance of the evidence and how admissible it could be in court settings. Thank you very much for the previous two segments, sir. Unfortunately, we have reached our final segment already, even though there's a lot more areas that we can touch. But I believe we'll just hit the nail on the head and be very specific with the information we want to give to the viewers. When it comes to the current context as well, moving forward, now as we just previously got done mentioning with the electronic evidences aspect, especially with our mobile phones and CCTV cameras, with evolving technology, we see artificial intelligence also coming about. Now, when it comes to the court procedures in Sri Lanka and the laws surrounding evidence and its admissibility in the country, do you think that we require more reforms moving forward, or is there already an enough framework for us to actually refer back to, especially when it comes to AI? Now, there's deep fakes, there's voice modulations. So how exactly does the judicial aspect actually discern if the evidence is admissible? What are the loopholes there? How can we navigate it?
This is a new thing that AI concept where we don't have proper mechanism to adapt that, and how are we going to use it? We have to be very careful if we are going to use it in criminal court, because we can get some sort of knowledge about things that are there by using AI as a help tool. But if you are using it to adapt the evidence, of course, it's a big difficult thing, and then we have to be very careful, and we must have new laws coming in, and we must discuss these matters at length, and then only we are in a position to put forward as evidence if we want. But as you said, if we show to the court that this evidence is improbable, then the court will think that you can't expect, especially accept the evidence and then convict the person. Now, especially we are talking about heroin or any other mechanism where police say that a lot of bombs have been recovered, possession of heroin, and then firearms as well. All these matters, no verbal evidence, the people can't see that, police are investigating, they make notes and they say the story. But if we are going to say a story which cannot be acceptable, and then if the court is of the view that story is improbable, that evidence cannot be accepted and convicted. So that is also one area we have to be very careful when we are producing evidence before court. The Attorney General's department will come and present the case. They haven't seen it. What they do is they get the IBXX, we call them as IBXX, and then because all the documents and the evidence and the notes, everything will be given to the Honorable Attorney General, and from the Attorney General department they send the indictment which will be served to the accused. But the State Counsel who has the file will submit the evidence to court according to the file available to him. Beyond that he can't go. So that is how some cases are failures, because though they produce those documents, those evidence, the court will not accept those evidence. And finally, the accused will be acquitted. So, as we say, in a criminal matter, court will go into the merits of the matter and see whether the cases are being proved beyond reasonable doubt. Now, then only they are in a position to finally convict the accused. So that is, we have to be very careful by when we are collecting the evidence and informing the court about the correct way of presenting is also very important. That's why I said improbable stories will not be accepted by court at any time.
That is very essential as well, the fact that we have to understand as general public as well, in the public sphere, if we see any sort of criminal activity, exactly how to tackle and how to actually ensure that the evidence that you may have been able to collect is admissible rather than inadmissible in the court setting. We are running out of time, but as a final question, I'd like to ask you one of the final questions if we have more time. Relating to what we can expect to see in the legal landscape moving forward when it comes to the changes that could be made. As a professional that has been practicing and is a President's Counsel as well, you would have, of course, some sort of understanding of where the direction is headed when it comes to evidence laws in the country, specifically in a criminal procedure setting. Do you think we're heading the right way? Do you think that there's discussion on reforms and maybe amendments? What are your thoughts on that, sir?
Yeah, that is also a very important question you have asked, because now at the moment we are considering about the delay. The Chief Justice, Lordship the Chief Justice, had specifically stated to the judges that you must hear the cases. Sometimes outstation courts were not functioning on Fridays, so he has given necessary instruction. You have to work on Fridays. Even if you want to do administration work, you can come and do it on Saturdays, but Friday's work is essential. That means that we have to finish those matters as soon as possible. So for that purpose, we have introduced a special new area where pre-trial conferences are concerned. Pre-trial conference, when it is there, the prosecution will give all the details to the defense for them to go through it and say whether they are going to admit some of the evidence which are relevant and can be acceptable. If that is so, then we can curtail the cases and then proceed further. And finally, the important 1 or 2 witnesses will be called and then cross-examined. Thereafter, court can go through the other documents, because those documents or the other evidence are being accepted under 420 of the Criminal Procedure Code. That is called admissions. Admissions are there to curtail the cases. Then finally, the court will proceed with the trial, and then we can finish those trials as soon as possible.
And finally, sir, as a note for us to end off on, now this discussion can be taken as a public service announcement of sorts, an education for individuals that would want to understand the basics of evidence law and what role we can play, especially when it comes to maintaining the integrity of evidence that we can collect. Is there a message that you would like to deliver to our viewers that are watching specifically?
Yeah, that's a very important thing we must inform. Don't get afraid to come and give evidence. At the moment, you will be given every opportunity to come to court, and you will be looked after very well, and you will be asked relevant questions only. If the defense even asking unnecessary and unwanted question, court is there to prohibit that. So important thing is, when there is a crime, it's against the society or the state. So not to an individual. So it is your bounden duty to come and narrate the story in a proper way. Immediately you must give the necessary particulars to police, and then once you are called to the court to give evidence, you must come and narrate the evidence in proper way, and then only the culprit will be sent to jail. So that is the very important area. Don't blame to the others. Are you unnecessarily this accused has been acquitted because we saw him doing this through the media, but unfortunately he has been acquitted. So that is not the correct position. The correct position would be, if you are consistent with the story from the beginning, and if you narrate the story in a proper way, the court will definitely convict the accused. You don't have to worry about that. So in that way, you can help the society to eradicate the crimes in that way.
I believe that is a very perfect area for us to unfortunately leave off on this discussion. We have come to time, but thank you very much, sir, for coming to the studio once again and for trying to trickle down and help us understand this very vast topic of evidence. Thank you very much, sir.
Thank you so much.
All right, well, we leave you tonight with the words of Socrates. To believe without evidence or demonstration is an act of ignorance and folly. That's all we have for you tonight on Law, Land and Liberty on Other Than a News channel. If you had missed any of our programs, you can always rewatch by catching us on our YouTube page, youtube.com/OtherThanEnglish. And please do send us your feedback on feedback.adncenglish@derana.lk or via WhatsApp at 076 805 7933. Thank you very much for watching. Have a great night.